We've spent the last few weeks talking about Texas, lawmakers walking out, threats of fines, arrest warrants, all to stop a set of maps that would gut representation for communities lawmakers don't care about. We've covered fights in other states too. All of them matter. But what's happening right now at the Supreme Court, that's bigger than Texas. Bigger than any single state fight. Because if the justices go the way they're signaling, it could change the rules for the entire country. And it's not some far off maybe. It's a real case on their desk right now. Listen, there's no two ways about it. Gerrymandering is a power grab. You carve up the map so your side keeps winning, no matter what the voters actually want. It's about control, who gets a voice, and who's locked out. When those maps target minority communities, the main line of defense has been Section 2 of the Voting Rights Act. It says if the population numbers justify it, you've got to draw districts that give those voters a real shot at electing someone who represents them. That's been the law since 1965. It's been upheld again and again. Most recently in Allen v. Milligan, when the court told Alabama they had to create a second majority black congressional district. Now there's a case out of Louisiana, and here's where this becomes more than just another map fight. The Supreme Court was supposed to decide if Louisiana followed Section 2 when it drew its maps, but instead, the justices asked whether creating that second majority black district in the first place, the very thing the law says you have to do, might be unconstitutional. Black voters make up about a third of Louisiana's population. By the math, that's 2 majority black districts. Right now, they have 1. The legislature's new map keeps it at 1. That's why this lawsuit exists. To make the state follow the law, and now the court is questioning if the law itself should even exist in the first place. We've seen this court weaken voting rights before. In Shelby County v. Holder, they gutted the part of the Voting Rights Act that required certain states to get federal approval before changing voting laws. In Rucho v. Common Cause, they took federal courts out of the business of policing partisan gerrymandering. Every time, the result is the same. Fewer protections, more unchecked power for state politicians, and more communities shut out of representation. But this case, if the court decides that states can't draw districts to give minority voters a fair chance, even when the numbers demand it, then Section 2 is finished. And without Section 2, the Voting Rights Act is just a shell. It would open the door for state legislatures everywhere to lock in power and sideline voters they don't want to hear from. The Supreme Court is reviewing one of the last real protections for fair representation in this country. If they take it apart, it won't just redraw a few lines on a map. It'll redraw the balance of power in this country for a generation.